Today in Canada, we are facing a serious crisis. That crisis is the over-incarceration of Aboriginal people in this country. In 2014-2015, Aboriginal adults made up 22% of admissions to federal correctional services, but only represented 3% of the general population of Canada. That same year, Aboriginal youth made up 33% of the admissions to the justice system, but only represented 7% of the general population aged 12 to 17. That means that the percentage of Aboriginal youth involved in the justice system is 5 times the percentage of Aboriginal youth in the general population. There have been steps taken by the government and the courts to address this issue. The government added Section 718.2e to the Criminal Code. This section places a duty on judges to consider the unique circumstances of Aboriginal offenders, and in making their decisions, to consider all other alternatives to custody that would be appropriate. The courts clarified this duty in a 1999 case called the Queen and Gladue. In this case, the courts proposed a number of factors that judges consider when sentencing an Aboriginal offender, and these factors came to be known as Gladue principles. The focus of this presentation will be on Aboriginal youth bail decisions. Bail hearings are legal proceedings where it is decided whether or not an accused will be detained or released prior to their trial. Sometimes accused are released with conditions that they must abide by. When it comes to Aboriginal adults, the courts have said the Gladue principles do apply to bail decisions, but the courts have been a lot less clear when it comes to Aboriginal youth, and part of this presentation is trying to determine why. The other part of the research looks at ways in which Gladue principles can be more fulsomely applied to Aboriginal youth bail decisions. A search was conducted of all reported cases of Aboriginal youth decisions since 2003, when the Youth Criminal Justice Act came about. The Youth Criminal Justice Act, like Gladue principles, also emphasizes and encourages alternatives to custody to address over-incarceration issues. However, Gladue principles are a lot more than simply saying, how do we avoid jail for this individual in these circumstances? It is crucial, in law as well as in other areas of society, to consider the ways in which colonialism, the residential school system, and systemic discrimination has affected and continues to affect the lives of Aboriginal people in this country. Ensuring the meaningful application of Gladue principles at youth bail decisions is but one way we can work towards a more just and equitable legal system and society.